Hey everyone, it's been a while since I made a video. Been working on a lot of stuff, a lot of cases, been fighting. Had to work on an eviction, still working on that. Doing an appeal on that, and then working on an appeal because the court is trying to do an evaluation to see if I'm competent to stand trial, which is kind of weird because I went to court on another one, and I just want you to see there that I didn't plea, and the court accepted that. And we also have the judge recused himself from another case. I'm suing the tow truck company again that took our vehicle. It's that old video with Caleb in it, and so we're suing them again because they sold the vehicle during litigation, and they're trying to declare me a vexatious litigant. But thanks to use of L on high frequency radio, directing us to use Google Scholar to get your case law. It's pretty simple, but right here, the judge. It's the first time I've ever seen a judge declare under penalty of perjury. Right? He removed himself from the case, which I see as it's a big win. And then they ended up taking another vehicle, but the lady had already. She's in the original case with the exemplified court orders. She had already acknowledged the tribe's jurisdiction over her vehicle and had gifted it back. She gifted back my truck. And as consideration, I paid for the tow fee, even though I didn't have to. I offered that to her because I didn't want her to lose out. But now I'm going to have to sue her for taking the vehicle because she knew beforehand, and they shouldn't be touching my vehicles anymore. So it's a basic outline of this one is for my friend. I'm fighting to get him out because he started his officer training under the tribe. And so I give the statement of the facts. But right here is where you kind of state, I put it in an appellate format where you state the injury, kind of what it is. So as a federally recognized American Indian tribal chief, the plaintiff, Mr. Jejena, has the right to exercise eminent domain upon the property, which is a waiver of the defendant's immunity under the plan of the convention, as well as Mr. Arande having immunity from defendant's civil regulatory claims as an officer, pupil of the tribe. And then the standard of review is the court should review de novo. So I got all these case law off of Google Scholar. Issues of tribal sovereign immunity are reviewed de novo. Indian tribes are domestic dependent nations that exercise inherent sovereign authority over their members and territories. Suits against Indian tribes are thus barred by sovereign immunity, absent a clear waiver by the tribe or congressional abrogation. Tribal sovereign immunity extends to both the governmental and commercial activities of a tribe, whether undertaken on or off its reservation. The scope and applicability of tribal sovereign immunity lie within the plenary control of Congress. Like foreign sovereign immunity, tribal immunity is a matter of federal law. As a matter of federal law, federal recognition of a tribe affords important rights and protections to Indian tribes, including limited sovereign immunity. Federal recognition may arise from treaty, statute, executive, or administrative order, or from a course of dealing with the tribe as a political entity. When the political branches of the federal government decide to recognize an Indian tribe, courts are obligated to respect that decision. Tribal sovereign immunity extends to tribal officers when the sovereign entity is the real substantial party in interest. The state of California and all its agencies are prohibited from impairing the obligation of their contract with the Kingdom of Heiahawa. The estate having passed into the hands of the Kingdom of Heiahawa, the state of California is restrained either by general principles, which are common to our free institutions, or by the particular provisions of the Constitution of the United States, from passing a law whereby the estate of the Kingdom of Heiahawa could be constitutionally and legally impaired and rendered null and void. A settlement agreement is a contract, and the legal principles which apply to contracts generally apply to settlement contracts. And so these cases go with the facts that we stated above, that we have a contract with the state with the consent of Congress's representatives to the Department of the Secretary of the Department of the Interior, the Assistant Secretary of Indian Affairs, and the Office of Federal Acknowledgement, and the courts giving deference under statute and regulation, which is first for regulations which are promulgated by the administrative agency. Courts give what's called seminal or hour difference, and then when it's a statute, they give deference to the agency through what's called Chevron deference, and that's for any ambiguities or how the agency interprets the law. Federal courts have determined Indian tribes to exist under a federal common law test. And then because our orders were exemplified, the Constitution comes into play with the full faith and credit clause. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general law, prescribe the manner in which such acts, records, and proceedings shall be provided and the effect thereof. And then this is the statute. The acts of the legislature of any state, territory, or possession of the United States, or copies thereof, shall be authenticated by affixing the seal of such state, territory, or possession thereof. The records and judicial proceedings of any state court, of any such state, territories and possessions, or copies thereof, shall be provided or admitted in other courts within the United States and its territories and possessions by attestation of the clerk and seal of the court annexed, if a seal exists, together with a certificate of a judge of the court that the said attestation is in proper form. Such acts, records, and judicial proceedings and copies thereof, so authenticated, shall have the same full faith and credit in every court within the United States and its territories and possessions as they have by law or usage in the courts of such state, territory, or possessions, and from which they are taken. And then this is the case which says that records and proceedings were entitled in each state to the same faith and credit as in the state of origin, and that inasmuch as they were records of a court in the state of origin and so conclusive of the merits of the case there, they were equally so in the forum state. And judgment of a state court as constitutionally entitled to be accorded in the courts of sister states, not simply the faith and credit on conclusive evidence, but the validity of final judgment. And then holding that the clause requires states to accord the same force to judgments as would be accorded by the courts of the state in which the judgment was entered. And this is a per curiam, which means the entire court was in agreement with respect to judgments. The full faith and credit obligation is exacting a final judgment in one state if rendered by a court with adjudicatory authority over the subject matter and persons governed by the judgment qualifies for recognition throughout the land. The judgment of a state court should have the same credit, validity, and effect in every other court of the United States which it had in the state where it was pronounced. And then we, the Kingdom of Hawaii, as a federally recognized American Indian tribe, may not be terminated but by an act of Congress. Only Congress can divest an Indian reservation of its land and diminish its boundaries. This one is for presidential powers. The President of the United States has plenary powers in the foreign affairs field, not dependent upon congressional delegation. The express power of the President to recognize foreign nations and how this becomes the supreme law of the land under Article 6 of the Constitution. Marbury versus Madison. So because when they say, oh, well, you're not on the list, well, it doesn't matter. According to Marbury versus Madison, in the case of recognized American Indian tribes, the law orders the Assistant Secretary of Indian Affairs to record them. When, therefore, a tribe has been recognized as described pursuant to USC Title 25, Section 5130, Congressional Findings, the order for their being recorded is given, and whether inserted in the book or not, they are in law recorded. This is the Section 5130, Congressional Findings. The Congress finds. 1. The Constitution as interpreted by federal law invests Congress with plenary authority over Indian affairs. Ancillary to that authority, the United States has a trust responsibility to recognize Indian tribes, maintains a government-to-government relationship with those tribes, and recognizes the sovereignty of those tribes. 3. Indian tribes presently may be recognized by Act of Congress, by the administrative procedures set forth in Part 83 of the Code of Federal Regulations, denominated procedures for establishing that an Indian group exists as an Indian tribe, or by a decision of a United States court. And because Congress vested California courts under Public Law 280, those courts become an Article 1 court, which is a United States court. And a tribe which has been recognized in one of these manners may not be terminated except by an act of Congress. Congress has expressly repudiated the policy of terminating recognized Indian tribes and has actively sought to restore recognition to tribes that previously have been terminated. The Secretary of the Interior is charged with the responsibility of keeping a list of all federally recognized tribes. This list published by the Secretary should be accurate, regularly updated, and regularly published. since it is used by various departments and agencies of the United States to determine the eligibility of certain groups to receive services from the United States. The list of federally recognized tribes which the Secretary publishes should reflect all the federally recognized Indian tribes in the United States which are eligible for special programs and services provided by the United States to Indians because of their status as Indians. Code of Federal Regulations 1.2, the applicability of regulations and reserved authority of the Secretary of the Interior. The regulations in Chapter 1, Title 25 of the Code of Federal Regulations are of general application, notwithstanding any limitations contained in the regulations of this chapter. The Secretary retains the power to waive or make exceptions to his regulations as found in Chapter 1 of Title 25 CFR in all cases where permitted by law. The Secretary finds that such waiver or exception is in the best interest of the Indians. And then United States Code, Title 25, Section 5123, D2. If the Secretary does not approve or disapprove the Constitution and bylaws and amendments within 45 days, the Secretary's approval shall be considered as given. Actions to enforce the provisions of this section may be brought in the appropriate federal district. And then H, tribal sovereignty. Notwithstanding any other provision of this act, that means nothing stands except this. 1. Each Indian tribe retains inherent sovereign power to adopt governing documents under procedures other than those specified in this section. And 2. Nothing in this act invalidates any constitution or other governing document adopted by an Indian tribe after June 18, 1934, in accordance with the authority described in paragraph 1. These are all the videos, shorts of Amador County Sheriff acknowledging and recognizing our tribe and documentation, verifying that it looks to be all in order. This one is this case, the purpose and effect of the act. That's section 500123 F through G. The purpose and effect of the act was to eliminate the distinction between created and historic tribes. The amendment was intended to end the distinction which had been drawn since at least 1936 between the powers of historic and created tribes. United States Code, Title 25, Section 194. In all trials about the right of property in which an Indian may be a party on one side and a white person on the other, the burden of proof shall rest upon the white person, whenever the Indian shall make out a presumption of title in himself from the fact of previous possession or ownership. And the case that backs that or that defines what that means, but in the view of the evident purpose of the statute and its use of the term presumption, which the white man must overcome, we are in agreement with the two courts below that Section 194 contemplates the non-Indians shouldering the burden of persuasion, as well as the burden of producing evidence once the tribe has made out its prima facie case of prior title or possession. And then United States Code, Section 1302, A5, so constitutional rights in general. No Indian tribe in exercising powers of self-government shall take private property for public use without just compensation. And Penn East versus New Jersey was decided. States may be sued only in limited circumstances where the state expressly consents, where Congress clearly abrogates the state's immunity under the 14th Amendment, or it has implicitly agreed to suit in the structure of the original Constitution. The states implicitly consented to private condemnation suits when they ratified the Constitution, including the eminent domain power, which is intrinsically intertwined with condemnation authority. Separating the two would diminish the federal eminent domain power, which the states may not do. And then in our agreement, the accord and satisfaction, clause 2, subsection B, I was the respondent, and I reserve the right to enforce any supplemental charges. So based off of those two things, the state has waived its immunity when dealing with our tribe. And then plaintiff is a federally recognized American Indian chief. Mr. Jejena is a federally recognized American Indian Chiricahua Apache chief of California and Nevada Territory. A protected party of the Treaty of Santa Fe, 1852. This is evident by the exemplified U.S. Article 1 court orders and settlement contract with the U.S. Secretary of the Department of the Interior and presidential recognitions and equitable executive orders that are provided. Plaintiffs are immune from the defendant's claim, as well as having the right to exercise eminent domain upon the property. Any and all state immunity is waived agreeable to the contract. United States Code, Title 25, Section 1302A5, Penn East versus New Jersey, the Plan of Convention waiver. For the reasons stated above, the court should see the unconscionable use of past nonviolent civil regulatory offenses as a trifle, which the law should disregard when it is to prevent the lawful use of a firearm to protect life and prevent injury, especially that of children. This falls within the Second Amendment and incorporated through the 14th Amendment. And that's regardless of Officer Arande's qualified immunity from Lyon County's claims and constitutionally protected. And then the relief that we're asking. So basically they have to go against this foundation, and I don't see how they can with our exemplified documents, them having to give it full faith and credit, it being a contract, and having giving courteous deference to the presidential recognitions. But like I said, the judge recused himself from the prior case, which I see that we're winning, and they did not make me plea. No plea. Even though they didn't dismiss it for lack of jurisdiction, they did accept our oral motion as a motion filed in court, but it says was denied. But let's see. Here is the appeals. The appeal we're working on for, it's 4 volumes. We're working on for the landlord, and then we're working on another appeal for the evaluation, which is really weird because They wouldn't give me a copy of the doctor's recommendation. They said it's not filed, but it's received, and they can't give me a copy, which I find highly odd. How is the judge utilizing a document that hasn't been filed? And how does a doctor make an evaluation without me submitting to that evaluation? I chose to remain silent. And then not only that, is that because of the California bar rules, section 1.9, it's a breach of the public defender's loyalty, because it's the same law firm as the exemplified orders, and it would be injurious to those orders for her to now try to say that I'm not competent to stand trial because I choose to enforce those orders, and her, as the public defender, has been refusing her assignment to file a dismissal. And when she told me at the beginning she was going to have everything dismissed within 2 weeks, I emailed her. I made a record of that conversation. She didn't respond. I gave her a second email, and then she's trying to say that, oh, I never said that. I would never say that. It's up to the DA. It's like, no, it's not up to the DA. It's up to the judge. It's up to you to file the motion, the proper motion. But so that's where we're at today. But we're pretty much caught up with all the work that we need to do. And oh yeah, and the other thing is that during this eviction, when I went out looking for houses for sale, and I met a realtor, and she introduced me to I believe she said that she's Crazy Horse's great granddaughter or something like that, but she's from the Lakota tribe, and she gave me a reference to Stanford, and I've started to apply for Stanford to do the start my law degree, and I'm putting in for a transfer. I did school right before our eviction, and I got a 4.0 for that semester. I did business and ethics. I got 2 A's. I had to drop the other courses because I had an issue with the teacher, but I dropped it before it would show a withdrawal, and they would and the money would be returned back. So, but that school, they tried to count it against me anyways, trying to say that I was on academic probation, even though my grades showed a 4.0. But anyways, I'm going to go ahead and wrap this video up, and I hope that you take the time, if you need this information for for federally recognized American Indian tribes. This will help you, because that's what I really want to do. Is I want to become a lawyer and have a major in indigenous people's law, and I don't know, maybe one day be a Supreme Court justice. But from what I hear from Justice Thomas, it doesn't pay very well, and he would prefer to have a regular job. But I guess it's not supposed to be for the job, it's supposed to be for the honor. So, yep, that's it. Guys, have a good day. Peace, family. Bye.